All right, we're going to pick up part 4 where we left off last time, discussing the death penalty as far as the idea of limitations on cruel and unusual punishment. And one of the areas that usually gets challenged a lot is the idea of death penalty. When we talk about guided discretion laws, meaning, for example, the use of death penalty for two different reasons, such as aggravating circumstances. And aggravating this applies to most different charges, whether you have aggravating circumstances, you can have aggravated battery, for example. We'll get into that later in the semester, talk about what different aspects can cause it to be aggravated. But in the sense of death penalty, was it heinous for some particular reason? Typically, it may deal with how an individual, if it has to do with, usually it's murder, for example, when it comes to death penalty, was the person treated heinously? Were they it sounds terrible to say, oh, well, because killing someone is bad enough as it is, but was it done in such a way that was beyond what would be considered any reasonable response? In essence, if you stab someone 30 times, for example, that's probably a bit heinous. If you kill multiple people, that's also an aggravating circumstance. Age might be a factor. For example, if it's a child, those are all aggravating circumstances, meaning it bumps up that level, right? Whereas mitigating might be more so on the side of defense, okay? What sort of mental capacity does a person have? Not only like mental illness, but also understanding, meaning like IQ and things like that get factored in. Even though I may not completely agree with how IQ was designed and how accurate it can be, it is still used at times for different things in court as a mitigating circumstance, for example. Also, had this person been a victim themselves in some capacity? What sort of defense was used? All right, so not necessarily a self-defense type of thing, but was this person, like I said, had they been victimized by that individual that they killed, for example, or were they intoxicated to where they really didn't know exactly what they were doing? What were other factors that, in a roundabout way, what are the factors that would alleviate or take away some of that ability to have the criminal intent to commit such crimes, all right? So that's what we're looking at as far as aggravating and mitigating circumstances. But then also, you can look up this court case. Essentially, I just gave the basic idea of what it decided. If you want to find out the details to it, feel free to look it up, read it. It would be interesting. Excuse me. But the court ruled essentially that mandatory death penalties were unconstitutional. You cannot say because this person committed X crime. Let's just say it's murder, all right? Because someone committed murder, you cannot, as a state and hence as a court, you cannot say, well, the only option you have is to find this person to be guilty and put them to death penalty, or put them to death through the death penalty, or acquit them. Okay, in essence, find them to be not guilty. Those two options are pretty far apart. So basically what it says, you can't just offer that. And it continues on here with Greg v. Georgia, okay? Essentially what it was saying was it was limiting, because that's what happened in Greg v. Georgia. The state of Georgia was essentially telling the people, or telling the jury, these are your only options, and there was no intermediate choice. Kind of like going back to Woodson v. North Carolina, same basic concept. So eventually, what comes of that is, if there is a particular case where, okay, so how trials work, right? You have your trial. Let's just say the defendant is found guilty of murder. All right, now you have sentencing that you have to go through. Separate deal, a lot of times, and so you end up having the sentencing. All right, well, are you going to sentence them to death, or usually the other option to that is say life in prison. All right. So if they're found guilty, that's kind of the you've given the jury, and in sometimes some cases it'd be the judge, but usually the jury, you've given them another option besides the death penalty. You've given them life in prison, or maybe they may say, some states may say 25 or 50 years per offense. Like say if it was a multiple murder charges, in one particular case, each individual or each victim might add on, say, 50 years. Okay, so those are just some examples of alternative options that would be available for in replace of simply just saying the death penalty. So, all right, I think you guys get that pretty well, grasp it pretty well. If not, like I said, you guys always, and it doesn't matter what we're talking about, you can always email questions, and I would always much prefer that we talk about this in the classroom and get good discussion about it. But needless to say, if you have questions about it, let me know. And this is a video that you can watch on your own using PowerPoint that details how the lethal injection typically works. I know it's been a few years back now that the company that used to make the lethal injection cocktail, if you want to call it that, for pretty much every state or a lot of different states and countries, whatever, they stopped manufacturing that. And so therefore people had to come up with their own versions of it, and kind of led to some problems because it wasn't working as effectively, and they weren't sometimes doing it in the right order, which is causing problems. But yeah, this video kind of goes into explaining exactly what lethal injection, the order that different drugs are used. If you want to call them molecules, you can. If you want to say different substances that they were used, it kind of goes into what each one does and the reason why it's put in that particular order. Okay, so here's another one. That second area where people want to challenge the whole notion of cruel and unusual punishment, they'll say, well, sentence length is too long. All right, and there's no real big way to explain that. I think that's pretty straightforward. They're saying that, for stealing, for example, the third strike rule, is that truly effective? Is that fair to say? Granted, there's a problem if someone commits 3 felonies. There's obviously some type of problem. They need to adjust their decision making. But doesn't matter what those 3 offenses were or are. Okay, and if it does, okay, well then shouldn't the punishment fit more so what the crimes that they've committed? So 3 felonies, if you want to have some type of mandatory sentencing, that may be feasible, but make it to where it's not, in essence, going overboard with it and saying, oh, well, now you have to spend your life in prison, okay? Because I think you're burdening not only that person, but also the state itself to take care of someone, because there's a lot of money that goes into taking care of prisoners. So double jeopardy is an interesting thing we have. So you have essentially what double jeopardy is. You can't, the generic way of saying it is, can't be charged twice for the same crime. It's a little bit more detailed than that, as far as there are certain times where you can be charged with the same type of offense. But what we're going to cover first is this concept of what it truly does prevent or cover. So correct, you cannot be tried twice for the same offense, which includes you cannot be re-prosecuted or, in essence, brought back for a trial by the same court in the same jurisdiction. If you were acquitted, in essence, found not guilty, or even if you were convicted, you cannot be brought back for an additional charge on that particular incident, all right, that particular case. It doesn't, however, you got to be careful. I'll talk about this in just a little bit when I talk about some areas it doesn't cover. Yeah, you can't re-prosecute after someone's been convicted of a given crime. Yeah, that's true. But there are times that if there was something that occurred around that same incident that doesn't really develop until later, that can be considered potentially a different event. So we'll talk about that in just a few minutes. All right, and the last part here, if you are subjected to separate punishment for the same offense, okay? So what's talking about there is if you have multiple levels of the same thing, so it doesn't matter whether it be, if basically two laws are written or two laws and two different violations are written to where they're basically the same, then you cannot be charged with the same, the same thing. For example, here's a really simple one. I hope makes sense. You cannot be charged with both. If you've only, I say only, if you murder one person, you cannot be charged with both murder and attempted murder, because both contain the same elements up to the point of actually one is completing the task, if you want to call it successfully, okay, meeting all the elements of murder. Technically, have you met all the elements for attempted murder? The answer could be yes, but it's not, but you can't charge someone with both of them, okay? So just like same thing goes, if I'm on trial for attempted murder, you can't write it for murder because that didn't meet that. But usually it goes the other way around. People say, well, why can't we charge them with both? It's because you go with the elements, or you go with the prosecution that would be the highest level that you know that all the elements have been met. So all the elements have been met for both. I said attempted murder and murder, but since murder was met and murder is higher, that's typically what we're going to go with. If I didn't have enough evidence to get all the way to the top charge, whatever it was, but I could get a lower charge, that's what I would, as an attorney, I might want to make a deal with them and say, okay, accept the lower charge, and we won't go to trial for the less or for the other offense, right? That I think I might have difficulty proving. All right, and let's see. All right, here's another thing. Federal and state statutes are considered separate. So if you get charged for a particular offense that is both, let's just say at the state level, and you some evidence is thrown out, so therefore you're probably going to, the state won't be able to have enough information or evidence to convict. What can happen, and has happened before, is the federal government will come in and say, well, we have this evidence that was, for whatever reason it was thrown out at the state level, we don't have that issue. If it was a search and seizure issue in terms of failing to get a search warrant in the right manner, if it was a state issue where they made that mistake, but the federal level, whenever they're doing their investigation, didn't make that mistake, well then, or they have other evidence that the state doesn't have, what will happen or can happen is, the state may dismiss their case or make it dropped. It may be found not guilty, whatever the case is, but the federal courts can come in and actually charge someone, have a trial over, even though it's the same stuff. There are two different offenses because, like I said, one's a state level, one's a federal level, and it doesn't really matter which is which. It just depends on which one has better evidence to help out. So, all right. So here's another thing. I'm going to get into the Blockberger rule, and basically consider the same. Offenses are going to be considered the same if two separate statutes contain the same elements. This is kind of like what I was talking about earlier, right? This is when I gave that, I said attempted murder, but what can happen here, same basic concept, is first degree murder, second degree murder. The only difference between the two in those states that rank them that way or delineate them that way is the only difference may be premeditation. And so therefore, if there was premeditation, you aren't going to charge someone with first degree and second degree. You have to pick one of those two. But same thing goes with residential trespassing and burglary. What's the difference there? One is, and this is kind of a thing, So people get confused on burglary, what burglary is. Burglary isn't just breaking into someone's house, okay? It is getting onto their property, say into their home, and committing a felony while in there. And that felony does not have to be murder. It can be aggravated battery, rape, arson, things on those lines. But essentially, that's the difference. Just because someone, all right, say I'm a homeless person who needs a place to stay, so I break into or I find a way into your garage to keep warm during a storm. That's not burglary. Unless I steal something or do something other, some other activity that's illegal while I'm in there, or that's the reason why I'm getting into that residence, I should say, then it doesn't count as burglary. Okay, so um, double jeopardy does not apply when, as you can see here, I'm going to list these conduct committed after the first prosecution. So if I break into someone's house and I set their house on fire, that's fine. But later on, not as a connected reason, like it's not concurrent. If someone ends up dying, okay, or I end up murdering someone later that has nothing to do with that particular burglary and arson, then it doesn't matter. You can still be brought in, even though it's in the same string of events. There's enough of a separation, or it occurred in a different location, or something like that, that says, well, that's not. It's not bringing in the same charges and the same details. Okay. Also, defendant can ask for separate prosecution. They can break up the charges into multiple offenses. So you can't say, oh, well, you've already been charged with the events related to a particular incident. This also involves the same incident. Well, yeah, it's because your client separated these out and wanted separate cases for them. We can always discuss why you'd want to do that sometime, but either way, and courts of differing jurisdiction. For example, DUI has to do with, in essence, there's a lot of DUI courts, so that would be a different jurisdiction as opposed to a homicide that would be a trial court, right? Remember, DUI would probably be handled under the courts of limited jurisdiction, whereas vehicular homicide is going to be in your normal trial court, right? So just think about those. And like I said, you can see some of these increasing sentences. I'll let you look at those on your own. It's not a real big deal that we need to worry about in this class, in my opinion, at least. So let's look those over, and that finishes up chapter 2.